I guess we can start.
We can start. Okay.
Okay.
Distinguished guests, respected faculty members, fellow students, and friends, a very good afternoon to all of you. On behalf of IMS Noida and under the able guidance and support of our Director General, Professor Dr. Vikas Dhawan, and our Dean Academics, Professor Dr. Neelam Saxena, and our HOD Law, Professor Dr. Anjum Hassan, I welcome you all to today's session on entrepreneurship and intellectual property rights. This lecture is being organized by the Office of Dean Students Welfare in association with eCell of IIC, and it has been made possible through tireless efforts of Professor Dr. Govind Prasad Goel, Assistant Professor Mr. Santosh Sati, and Assistant Professor and IIC Coordinator Ms. Shobha Tripathi. I am Mohini Jaisinghani, your host for the day. I'm glad that you all are here and have joined us for this session. And I'm confident that at the end of this session, we would all carry back valuable knowledge and practical insights from this session. It's my utmost privilege to now introduce the program and the distinguished speaker of the day. Today's lecture focuses on entrepreneurship, that is at the heart of global economy. Entrepreneurship creates innovative solutions, generates employment, and promotes socio-economic growth. Deeply intertwined with this concept is IPR, which is intellectual property rights, that provides a legal framework to safeguard these very innovations, thereby encouraging originality and entrepreneurship. Today's session will unravel the strong connect between entrepreneurship and IPR, a connect that is very relevant and critical for students of law, management, and allied disciplines. At the end of this segment, at the end of the session, we are also going to float a QR scan code that you can copy and for your e-certificates. And now, coming on to welcome Mr. Balaji Damo to deep dive into this interesting topic. I would like to extend a warm welcome to him. He is advocate, founder, law to all, and a legal practitioner at the Madras High Court. Established in the year 2013, Law to All is a pioneering NGO that encourages legal empowerment across Tamil Nadu and beyond by providing accessible legal education and services. Mr. Balaji Damo comes with a rich experience of about 8 years in the insurance industry with expertise in claims management, legal negotiations, and alternative dispute resolution. He has worked and is empaneled with some of the leading insurance companies, including Bajaj Allianz, Shriram, GoDigit, and ICICI Lombard. At the Madras High Court, he focuses on civil as well as commercial litigation. Mr. Balaji Damo completed his legal education from Dr. Ambedkar Law University and went on to specialize in intellectual property law. He completed his LLM in mercantile law from Annamalai University that strengthened his foundation in both business as well as commercial law. With that, I would like to invite Advocate Balaji
Thank you,
Damo
ma'am.
to please take over the
Firstly, I'd
session.
like to thank
Over to you,
IMS
sir.
Noida and then Dean Students Welfare and Mohini ma'am for this opportunity. Let's continue with the session now. I'll share you my screen. Just confirm me whether my screen is visible for you guys. Is my screen visible for you guys? Yes. Okay.
Sure, sir, it is.
Yes, sir.
Yeah, you already heard an introduction about me. Let's go into the topic. Today we are here to discuss about entrepreneurship and intellectual property rights. Right. So here, speaking of entrepreneurship, entrepreneurship is part and parcel of IPR world these days. Wherever you go into your startups and you are going to start your own business or you are going to innovate something, all these things they need IPR. So entrepreneurship and intellectual property is must and it goes hand in hand. And in entrepreneurship, IP is a non-negotiable thing. So why this lecture on intellectual property rights? First, we will discuss about what is entrepreneurship, what are all the things you are going to know. Then the creativity innovation aspect of the entrepreneurship. Then we'll look into what is IPR and what are all the things related to IPR which is important for entrepreneurship. So first, the objective of the lecture, what I intend to tell you first, the role of IPR in promoting your entrepreneurship. So it is mean the IP will help you level up your entrepreneurship. So practical challenges faced by startups and other institutions, wherein the the IP which gives them a better edge. So we'll be looking after that. Then procedures regarding patents, trademarks, copyrights, and designs. I'll be introducing to what is patents, what is trademark, what is copyright, and what are all the intricacies you need to know. And we will also discuss regarding the case laws regarding the patents, trademarks, and copyrights. Then for inspiring innovating thinking, these are all the things we need to know from the objectives. Then what is entrepreneurship? Coming to entrepreneurship, entrepreneurship is the process of designing. First, you have to do it internally, then it has to be launched, it has to be put into practice, then the business has to run. So that is what putting things into the motion. So first we innovate, then we risk take and we commence, third we create value. Where do we create value? We create business. And to just creation of business, we need to protect the business. That's where IPR comes in. That's where IP comes in. We'll discuss about that in next slides. An entrepreneur is a person, individual, who creates a business and he takes all the risks and everything is on him. Whatever the innovation, thinking, the idea, the design, the pattern which he creates, everything is on him and is an individual. In some cases, when it becomes a startup, it becomes a company, then the founder takes all the responsibility and founder appoints a person along with him to take up the responsibilities and they are going to do the work. So let us discuss about the startup cycle. We will discuss the thing with basic thing as startup in this lecture. So first thing is idea. What you ideate, you can intend to start a business like Ola, Uber, Rapido, or you can start a pharmaceutical company with a specific drug wherein you wanted to bring a drug for cancer or diabetes. That's idea. Then innovation. What do you innovate? Ideas, everybody are abundant with ideas. I have idea, you have idea. Everybody in this meeting would be having an idea. What do we innovate? With the idea, what do we bring? What do we bring novel to the market? That's when the business kicks in. That's when the innovation is important. Idea and idea should be backed by a good innovation. Then execution, not just innovation, then innovation has to be executed properly. That idea putting in, you innovate something novel and then it has to be executed. These things are very important. And the last thing is growth. When the idea after being innovated, putting into executed, execution is one part and then multiplying and scaling it is the biggest challenge. That is the growth challenge. This is the startup cycle which we call. Okay, how entrepreneurship in 21st century is. First, let's see, first social entrepreneurship, then tech-driven startups, then digital economy and e-commerce. We'll see the examples for it. So you can identify these logos easily, right? So when you can identify these logos, it is protected by a trademark, right? So they have been given a certain identity wherein they do trade with these marks. These things are also backed by the intellectual property rights. Let's see. First, innovation as a startup of the entrepreneurship. What we have seen, first idea, then comes innovation, the novelty aspect. So innovation is first. Then creativity leads to unique products and services. After the innovation, you cannot stop with the one product. It has to be growing with the multiple products. So there comes creativity and innovating in each and every idea which you come up with. Then competitive advantage through innovative solutions. Here the word competitive advantage is very important. Why? Because this competitive advantage is what you have been given through the IPs. So you have been creating something and it has been protected with your intellectual property. What sort of intellectual property? There are different types of intellectual properties which we are going to discuss. It will give you competitive advantage. It will protect you and shield you from others exploiting your effort and your innovation and your thinking and your idea. This is what IP is all about. First, monetization of IP. How do you monetize from IP? So we have thought what is idea, what is innovation, what IP is going to do. Now, how we monetize the IP. First, turning IP into your business value. You can turn your IP, that is your intellectual property, into your business value. How? Through licensing. There are a lot of licensing model available now. For many companies are doing licensing. So then franchising. You can see a coffee shop being franchised elsewhere. Say if there is a coffee day is a operating business, and it is franchising its coffee day business across the country. Say they have multiple branches, they can't handle every other branches. What they would do is they get their IP, their own IP, and they franchise things. What do they franchise? Their coffee and their coffee model and the trademarks and everything is being franchised and authorized, and the person who is getting the franchisee can use all these that's coffee day trademark and coffee beans and all that, and he could run the business. So he won't be having the uh, effort. The first part which we talked about, that is the idea innovation, that part is already taken care by someone else. So you can just franchise the idea and the innovation which you have done, and you can make business. Uh, that is the concept of franchising. So licensing, franchising, you can monetize your IP as IP as a collateral for loans. In some cases, what you call this IP is intellectual property, right? So you use your collateral properties for you as your collateral. In this case, your intellectual property can also be used as a collateral. It also carries value. Your IP is also having value. This way, you can also monetize your stocks getting appreciated. You can also pledge your stocks, and through that also you can be monetize your business which you have grown and protected through your IP. Attracting investor with strong IP portfolio is the norm now. So these days you can see a lot of brands being positioning themselves. You can see Bold. These are some some important brands which we have recently saw, which has a lot of growth and a lot of potential. These names are also protected by trademark. We are going to see the case laws wherein these conflicts are also resolved before the courts. We will detailedly discuss what are all the situations happened and what is the issue before the court and what is being decided there. So this is monetization of IP. Then why an entrepreneur should know IP? What is the need for them? Why it is a must? Why it is a non-negotiable, which we already discussed. Why it is a non-negotiable is what we are going to see. First, innovation is the core of entrepreneurship. Without innovation, no entrepreneurship can be succeed. So it will be fading off over time. Innovation is very key. Not just innovation, first the idea, second the innovation, third the execution part. In the execution part, there will be a lot of hiccups, there will be a lot of copying. Like if you have invented a product wherein it's very unique, it should not be copied by the others. Then your IP protection will come. So every startup is built on a unique idea, product, and service. So uh, this is the baseline for every startup. If that idea is not protected, competitors can copy it easily. We'll see the examples later. So here, the duplication of the idea and making it better than even the person who initially started, because those with the deep pockets and bigger money to pump in, they can better your idea and in fact do it better and ahead than you. In that cases, if there is IP with you, then you can be protected at some level. So then creates a competitive advantage. What sort of advantage? IP protection prevents others from using your innovation. Say you have a specific coffee bean filtering method, which gives you wonderful aroma and gives you a very great taste. If you have protected that product, then it can't be taken away from you, and your competitors cannot be using that, and they can't achieve the taste. So such things are IP which you can save from your competitive advantage. Your competitors, you can save it. So builds brand identity via trademarks and product differentiation. So these trademarks, if you remember Pepsi, if I say the word Pepsi, you will remember the trademark which is used in Pepsi, that is red, white, and blue. Back in the days, Pepsi used to promote their logos even with a ball. That's a cricket ball which will be in the form of a Pepsi logo. That's how brandings and trademarks are deep rooted, and it has transformed to the entire lengths and breadth of India. So that's how competition marketing works, and trademarks reach people very deep rooted. So these trademarks, if I just tell a word, you can get that image in your mind. Say if I say Coca-Cola, you will be getting that Coke a red color, then Coca-Cola, the cursive writing which it's written as Coca-Cola, you will be getting that all those things. If I say MRF, you will know that MRF logo from Sachin's bat or Virat Kohli's bat. That's how they do their branding and their companies, and that is being trademarked. So these are all the competitive advantage through they are getting this advantage over visibility and not replicating this with the help of protection of trademark. Then attracts investors funding. How it will attract investor look for startups with strong IP portfolio. Why? Because the IP portfolio brings in a lot of visibility, lot of eyes, and lot of marketing, and that brings a lot of business. When the person has a strong IP, when I have given an example of Pepsi or Coca-Cola, their IP and trademark is so strong, a person who is having an option of 10 cool drinks in a shop will prefer the branding of Pepsi over there because it is visible, it is clear, he can identify it, and it is long standing. He has the exposure to that Pepsi trademark branding for over 20-30 years. That gives him the impression that it is safe, it is there, it is for a long time. So, such IPs bring you the confidence of the person who is buying it also. So it increases values and it reduces the business risk. Say if the Pepsi's logo is not protected, there will be tens and thousands of Pepsi logos around the streets, and you will be having cool drinks imitating all the Pepsi branding fully. So then there won't be market expansion and market capitalization by the Pepsi alone. So these are all the issues. Then creates competitive advantage, which we have already seen. Enables monetization. It can generate revenue through licensing, franchising, and sale of IP assets. The sale of IP assets, say if there's one example, there is a Campa Cola. There was Campa Cola. Campa Cola is like an IP asset. It's a trade name. It's now bought by Reliance. Now Reliance is using Campa and they are promoting the Campa. It's easy for Reliance to create another brand in their own name. They have created Geo, their own brand. It's easy for them to create another brand name like any brand name and sell their cold drink. But they chose already existing IP asset which is Campa. Why? Because the recall value, the example which I gave you regarding Pepsi. So that recall value and the trust people that built over the 10, 15 years would be it is great, and you can bring a new brand and establish that easily. Then what is builds brand reputation? This is what the reputation which we have talked all these times. That is Pepsi's reputation. Now you could see the logos. Just by seeing the logos, you could identify the company and what are all the role what they are doing. Zostel is a hotel company. They provide you accommodation rooms like OYO accommodation rooms. Bharat Pay is what you use with your UPI wallet and cash payment, UPI payment, etc. PhonePe is similar, Flipkart, Paytm, Ola, all these things just by visibly seeing their trademarks, you could recollect what their business, what is their model, and how it has impacted you. Like already, whether you have been the customer, already you have used their services. How will be the judgment of the company will be based on the trademarks. So if I go to a hotel which has no board, my presumption would be how the hotel will be, whether it will be good or not. All these things would be running on my mind. If it carries a branding of a hostel, say it might have been a franchise which they have taken or which will not run directly by hostel. It is run by a person who's not exactly hostel, but he has got the franchise and he's running. But the name hostel itself will give you a criteria wherein your mind will think, okay, I've been to hostel earlier. It was clean, neat, and a good room. So you will expect the same room there, and the chances of being the same room because they give their name, they may maintain a standard. So it may end up as a good outing for you in a hotel. So that's what your branding and trademark gives you. Uh, so this is the brand protection and brand reputation which will bring you. The trademark and copyright create trust among the consumers. This is what we have discussed. So the trust factor, the recollectability factor, the association with the brand is all important. You know why these brands keep posting their trademarks in the football, even in football, in your jerseys you will have your brand. Even in cricket you have your teams carrying some trademarks in there. This is for the repeatability factor, then the adopting factor. So if I'm a Arsenal fan, Arsenal go with a branding of Emirates. So more than Arsenal, the Emirates name would be bigger. The person who's running behind Arsenal, who is a fan of Arsenal or say Real Madrid, they will have more association with the brand. That's why these brands spend crores and crores of money on the sponsorship on the jerseys. So that is also a key important branding, which increases the reputation of a brand in association with the key and important sports clubs. So strong IP portfolio signals credibility and professionalism also. So it builds the trust and it brings the credibility to the other end consumers, and it's also will bring a professional environment to the person who is using it. Then coming to IPR, we have shown entrepreneurship, how entrepreneurship will be uh, aiding the IPR, the IP world will be aiding the entrepreneurship, and how it coexists. Now let us look at what is intellectual property rights are. First, it is the legal rights given to the creator for the innovation. First, what we discuss, who's an entrepreneur is a person with the idea first, then idea turning into innovation, then execution. So we are discussing about the second part here. So legal rights given to the creators. Creators are like we can here say as innovators. Those who innovate, we are giving legal rights for them. What do they create and innovate? First thing, patents. Let's discuss detail regarding these patents about all the things. Just see what are all the intellectual property rights we have now. First, patents for the inventions. Whatever you invent, you are being given patent to it. Then trademark, which we already discussed regarding the brand identity. Whatever your logos, the colors you use, these are all coming under trademarks. First patents, trademarks, then copyrights. Whatever you do, you write, you sing, or you perform these things, everything will be coming under copyrights. It's a creative work. Then industrial designs. When you design a product, say the earlier instance which I gave you, a beautiful filter which gives us a better aroma for your coffee. Such things are product designs. The industrial designs which will protect you from your competitors copying that. So what is the legal framework of IPR in India? First, we have Patents Act 1970. So we already seen patents trademark for the respective acts we are seeing here. That's Patent Act 1970. Then Trademarks Act 1999. We'll look at the history how this came in 1999. We'll look at the history. Then Copyrights Act 1957, which protects the copyrights, your writing, your music, everything is protected in this Copyright Act. Then Designs Act. Designs Act, we will be looking what are all there. So in case of global, when you compare the to the global legal framework, WIPO is very important when it comes to IPR in the global forum. Then TRIPS agreement from the WTO. WTO is World Trade Organization. Then TRIPS agreement is also a part of it, which promotes the IP to a bigger level. Then Madrid Protocol, especially for the trademarks. We will look into what are all these one by one. First, WIPO. WIPO is World Intellectual Property Organization. What they do, they are specialist agency of United Nations. United Nations is the overall body, and WIPO is a specialized agency. It is established in 1967, headquarters at Geneva, Switzerland. So their main aim is to promote intellectual property. When the world has become industrial revolution and a lot of things has to be going in trans-border, because earlier there used to be colonization, everything is was under the British. Then there came a situation where across the globe, everyone started innovating. All the Europeans started innovating. Their innovations needed protection, not just in their own country, but across borders. That's how WIPO ended up protecting their IPs across trans-borders. So that is their important role. Their important role includes International Forum for IP Services, Policy, Information and Cooperation. So they promote all the IP related stuff. They administer key treaties on patents, trademarks, industrial designs, and copyrights. Important treaties to mention: Patent Cooperation Treaty that deals with the patents exactly. Then Madrid Protocol, which we already discussed, that protects the trademark. Then Hague system for the industrial designs. This Madrid and Hague are the places where the decisions were made. So it's been named after the places. So offers dispute resolution services in case of an international dispute with regard to this IPs. They also do that. Then they help and encourage the member states. What are all the member states? Say for UN, you have a lot of signatories. Say you have 194 signatories. They say so. All the countries who are there may be enrolled with UN. All the member states would have to develop the IP law. So what we have seen that IP has to be taken globally across trans borders. It has to reach all people. So in order to reach all people, it is necessary that all the countries will have the same laws so that their IP is protected everywhere in the world. So they help develop them the laws and the policies and help them structure. If the policies is not consistent with the WIPO guidelines, they will ensure that there is compliance with the WIPO guidelines. So as of now, there is 193 member states. So this is the body which sets international rules and framework for all the IP protection across the globe. And then let's see about the TRIPS agreement. So this is aspect of intellectual property rights is what the TRIPS agreement is all about. It's a golden rule book for the intellectual property under WTO. So it comes under WTO. It is a golden rule book is what they call this. This ensures the minimum standard of protection for all the IP holders, and this ensures that all the countries are also entering into this and taking care that all the IPs are protected. First, India is also a WTO member, and India is also bounded by TRIPS with regard to India. And with regard to Patents Act, India was also made a significant amendment in 2005 to include pharmaceutical and chemicals in the patents. That is the product patent. So there is something called process patent and product patent. Not to go into details about the patents. So just know that there is something called product patent also, which includes pharmaceuticals and chemicals. Everybody know there is a paracetamol in your uh, every medical box now these days. You have paracetamol 500. They came up with paracetamol 650, that is called this Dodo 650. They will be adding some more chemical to the paracetamol to make it more effective. Such product with the combination of chemicals also can be patented in order to have them the exclusive right to market that product. For example, which I gave you, that paracetamol combined with another special chemical which would give you a better result, that can be product patented. That product can be patented, no one can be selling that product. So such advantages over the competitors can be gained through obtaining such patents. So balance in IP protection with public interest. So there is something called compulsory licensing. Whenever there is an essential drug which needs to, say in case of corona, somebody has invented medicine to cure corona, but he is not ready to give it to everybody. But there is a pandemic situation, everybody needs to be saved. So in that cases, compulsory licensing may be given. So that protection of public interest also is ensured by the TRIPS agreement. So let's come into the what are all the minimum standards of IP protection. These are all the things which they ensure, that is TRIPS ensures minimum standards of IP protection and non-discrimination principle. This is very, very important. There should not be any discrimination between countries. Then enforcement mechanisms, then dispute settlement. These are all the roles of the TRIPS agreement. TRIPS and the TRIPS agreement talks about. So requires all member countries to provide basic standard of protection for copyrights and related rights. That is what we call in the 1957 Act ensures to us. Then trademarks, which is in 1999 Act. Geographical indication. Coming to geographical indication, there is a specific features for every geographical location. Say I am sitting in Chennai. Chennai is humid, hot, and everything. But in Ooty, you can expect chill climate, mostly under 20 degrees. So such geographical features would give a product an edge. Say if I am making chocolate in Chennai, if I am making chocolate in Ooty, the taste of chocolate would change due to the temperature and other things, other factors involving in all these places. See, there is a specific place in Tamil Nadu which is called Manaparai. They used to do this snacks which gives us the taste because of the products which they get there and the water and all those things contributed. They got the GI for that. So a lot of things with related to geographical specification, they get the identification as geographical indications. So we will also see an example through a case law for geographical indications, how they have got that, what is the significance, how it is getting there, giving them the edge to over others. So we'll look at that. Then industrial designs and patents. So these are all the minimum standard of IP protection which TRIPS guarantees in across these copyright, trademark, and geographical indications. So non-discrimination principle is foreign nationals must be treated same. So here it is mentioned no less favorably. So there is no favorable treatment here because if I am an Indian and I am filing before an Indian IP, say if a foreign company comes and file a IP before Indian law, it has to be treated all the same. So a domestic citizen, an international company or a citizen to be treated same in before the IP Act. There should not be any special treatment. Why? If we start discriminating domestic citizens for their IP, it will not be uh, it will not be inconsistent with the TRIPS or the WTO or WIPO conventions. It will be against the innovation which they have made that will be wiping off their struggle and hardship. See, the aim is to have a cross-border relation, cross-border applicability of the IP. So that would ensure only if they follow this non-discrimination principle. So the enforcement mechanism, enforcements will have civil, criminal, and broader measures, and IP violations will be tried in their own jurisdiction. And in case of special jurisdiction between two, three countries, and those details will be handled by WIPO. TRIPS dispute can be taken to the WTO dispute settlement mechanism, which we have discussed just now, making it enforceable at the international level. And there is a multiple country involved, this international level, it is better to settle the dispute through WTO dispute settlement. Then coming to Madrid Protocol. Madrid Protocol is the thing which happened in the Madrid. The agreement, they have arrived at agreement concerning international registration of marks. Marks is what we have discussed as trademark. The Pepsi round logo, which we have discussed, the Coca-Cola logo, and the colors which we have discussed, such marks are being treated and they are being given the recognition how to do it in this. So this was adopted in 1989, but it came to force in 1996. It is also administered by WIPO, which we have discussed two slides earlier. So here the member countries are over 110 countries are here. So earlier 193 countries we saw, here 110 countries. So what they are giving is single application. For getting the marks, single application, then international registration. The registration has to be international because across borders, if you want to use, it has to be centralized registration. So international registration. The protection in multiple countries is also ensured. Then management also made easy. First, instead of filing separate applications in each different countries, single application uh, would give you the trademark and it can be used elsewhere in the entire world. So WIPO records the marks in international register and it is published in the WIPO Gazette. Just like we what do you call we process law and we it has to be published to the Gazette. This register also will be published in the official Gazette. Only after publishing in the official Gazette, the trademarks will be conferred to you. You can designate or one or more member countries where you want to proceed the trademark is protected. So that is the where do you want to own the IP is your jurisdiction and that national law will be applied. So that is it. So that protection will be continued in multiple countries using this Madrid protocol and all the things decided in the Madrid things. Changes like ownership transfer, address change, these are all centralized and it can be done through this online processing itself and it governed by WIPO. So coming to Patent Act 1970, it is amended in 2005. So it grants 20 years exclusive right to the patent holder. So whatever the thing you patent, you have a right to hold it for 20 years. So for conditions of patent is it has to be novel. First thing which you have discussed is innovation and novelty. So that novelty factor is very important. Only if it is novel, patents will be given. Then involve inventive step. What you have added. There can be something. Say, say there is something called, say there is a formula E is equal to MC square. It is already there. So there has to be something novel over the top of it, and there should be an inventive step. You can't go back and say that E is equal to MC square. I have done these things. So there is no uh, another novelty over it. There is no inventive step over it. So there has to be something added to it. So you can say E is equal to MC A square. So you bring in A, then it brings something novel. Then it becomes an inventive step there. So you have made an invention on top of something which is already existing, and you are coming up with another new proponent. So in such case, it can be patented. So it has to be put into industrial use. It has to be have an application over it. Not just because you have known something, you have identified something, you can't be given patent. That has to be capable of putting into use. Then compulsory licensing, which we already discussed during the corona example, the compulsory licensing during emergencies should be done. Then fast tracking examination for startups. So we'll discuss about the startup India, which India has come up with. So for startups, fast track examination is done. Then regarding enforcement, it can be done from IPAB and civil courts. IPAB is IP Appellate Board. Then interim injunctions for infringement. If there is a patent infringement, there can be injunctions interim, and then subsequently there can be a law decided over it. There is a case law for it. Encon India versus Alois Woban defined patentability criteria. The things we have discussed here will be you can see that in this case law. I'll share you this PPT also. You can have a go through it. On a lot of case laws discussed here. You can also discuss that. With regard to Trademark Act, it's in 1999. You could have seen the TRIPS agreement 1995. After that, these trademarks, all these come into force. Trademark protects your names, logos, and slogans. What is name? The name Pepsi is you can call it as a name. The logo which you have discussed, red, white, and blue, that is logo. Uh, Slogans which they come up with their product. Uh, so the slogans are also very catchy at sometimes, and it also grows along with the brand. So these slogans are also trademarked. Trademarks is valid for 10 years initially and then renewable indefinitely. Whenever a trademark is renewed continuously, it can be held for uh, as long as they want. If it's not renewed, it can be taken over by the other person. Protection against passing off, cyber squatting, and dilution. We'll discuss about all these things. Uh, with regard to enforcement, IP Appellate Board, District and High Courts are it can be enforced. Remedies, we have injunctions, which we already discussed, and damages. Say if I use Pepsi logo and I have done some business and I have made reputation loss to them, they can claim damages from me. So that's how damages work. Then destruction of infringing goods. Say I have produced 10,000 bottles of a duplicate Pepsi with the same logo. That goods, if it come into the market, that will damage the reputation of the original trademark holder Pepsi. In that case, those goods which are produced with that the wrong trademark can be destroyed. So that also can be a remedy. They can seek them. Then with regard to case law, Tata Sons versus Manu Kishori. The word Tata, the Tata branding is an exclusive right to the Tata Sons, is what this case is about, and Tatas have won the case, and we can see that case also while we discussing the other things. Copyright Act 1957. This is comparatively the oldest right which you have recognized in Indian law. Covers literary, artistic, and music and software. Softwares are using the Copyright Act, and it is using extensively now. Apart from softwares, literary, artistic, and music. What is literary? If someone is writing a book on some topic, it is protected by copyright. What is artistic? Someone has a drawings or even fashion designing, such things are also protected under copyright. Musics, whenever a music director is composing a music, he has a right, or a singer who has sung, these things are carrying this copyright. Automatic protection on the following. First is creation and registration is advised. So automatic protection, this as mentioned. Then moral rights of the author has to be carried out with the copyright and been consistent with. Then with regard to enforcement, there is civil suit is the remedy, then mediation. So a lot of IP, they will have arbitration clauses with regard to their thing. It has to be treated with the inconsistent with the arbitration regulations also. And in certain cases, there will be criminal penalties, fines, and imprisonments. Case law, Eastern Book Company versus DB Modak. Originality in authored work is protected, is what decided in this case. Not going into the details, let's move to Designs Act 2000. So it protects visual designs that appeal to the eye. So we'll see an example of a case law for this designs particularly, that too specifically with regard to visual designs. Say if I'm a costume designer, I have invented something in a I mean, I have designed something unique which is eye-catchy to all, and they would value the design. There are people who value the design of a designer shirt, so that would cost more. So if you copy that design and you do your own shirt model replica of it, it would be a revenue loss for them. Such things will be also protected under Designs Act. So the validity is protected for 10 years and extendable by 5 years from the designs. So enforcement in civil courts handle these disputes. Case for example, Microlure versus Rajesh Kumar. This case will emphasize the importance of the design registration brief. So, with regard to trade secret, there is no specific law in India that protects the trade secrets. So, what the companies do is they use NDAs. NDAs is non-disclosure agreement or confidentiality agreements, which two people enter that they will be sharing the secret with me, maybe the trade secret or the combinations which they use. The condition is that I should not reveal the secret to anybody, or I should not start a company with the secret which I know from them. That would abstain me from doing or using that say secret and building a business, or telling them out, which would cause them a damage, or their business would affect from the me revealing the secrets to other persons. So it protects sensitive information like formulas. What formulas example? Like there is a Coke formula which is being protected under trade secret. So if there is a specific taste to Coca-Cola which comes from a formula which they use. So if the formula is out, they won't be having their unique specialty over the content, the Coke which they are selling. So such things are protected. Then client list. Say if I'm advocate and there is a list of clients, say 100 clients I have, and they are all big clients with a high stake billing every month. So in that case, my client list, or even a software company for that sake. So the client list should not be used against me, or my client should not be posted. In that cases also, these NDAs can be used. Then processes. There can be certain processes. There is a say there is a bakery in Bangalore, which which bakes a beautiful breads. So the process which they bake the bread uh, can be a trade secret for them, that would give them edge over a better taste in their food product. So such thing also can be considered trade secrets. So in this example, Dr. Reddy, which is a famous medicinal brand, uses NDA to safeguard their proprietary formulation, that is uh, making the tablets or the medicine. So what all we discuss? We discuss patent which protects invention, that is for 20 years. Then trademark that protects the brands for another 10 years and it is renewable per se. Then Copyrights Act which protects creative work, that is linguistic, artistic, music and softwares. So it's automatic protection. Then designs with protect about product aesthetics and designing, which is 10 years first, then 5 years to top up. Then trade secrets, which is called confidential information are protected, but it is not strictly by law, but via contracts between the parties, it is being protected. So, with regard to government initiatives supporting the startups, let's see first Startup India Action Plan, SIAP, then Scheme for Facilitating Startups, that too specifically in intellectual property rights, it's Startups for Intellectual Property Protection, SIPP, that's a scheme. Then IPS awareness campaigns across. First, the Startup Action India plan offers a fast-track mechanism for patent applications filed by startup specifically, provides 80% rebate on patent filing fees. Say if the fees is 100 rupees, you will be getting 80% cut. You have to pay only 20. So that's how it works. Then facilities free legal and technical assistance for the patent applications to in order to increase the patents from India. So we as a 1.5 billion people, our representation in patents and all these intellectual property rights are minimal. In order to grow and boost that, India is coming up with a lot of these facilities for them. Encourages startups to protect their IPs by offering financial incentives and simplified procedures. So their IPs get recognized and is also set in place. Then conducted by IPR cell of CIPAM. Uh, this is Center for IPR Promotion Management. campaigns to educate startups importance of IP protection. These are all done from the government end to protect the startups and to others. So, what are the strategies we may adopt to safeguard our IP asset? First, there should be a comprehensive IP audit. Say you have run a business, so you'll be having several touch points in all these acts, like say patents, trademark, trade secret, and everything. So there should be a comprehensive audit. Then, as soon as you find that there is a lacuna there, your IP has to be registered immediately in order to ensure protection. Then use NDAs and contracts. NDAs is non-disclosure agreement and contracts with your employees and wherever the trade secrets and other things involved. Then monitor and enforce IP rights. So first the protection part. Second thing is when there is exploitation, you should enforce your right, which is what we are seeing through that civil or criminal actions which you are going to take and or the damages which you are going to claim. All these things comes under this. Then leverage government support. There are a lot of things for startups which we are just seeing the government supports. You can leverage all those government support in order to ensure that your IPs are protected. Then identify all potential IP asset which we already discussed, that is innovative products, patents, brand names, logos, slogans, trademark, then creative content, softwares, copyright. With regard to registering IP, really file the patents on the innovative products, register trademarks for your brand identity, apply for copyright protection for creative works, whichever you do in your business. Then NDAs between employees, contractors, and partners wherever the state secrets would have touch points. Then include confidentiality clauses in all the agreements to ensure that your confidentiality is maintained. Then monitoring enforcing rights includes if infringement occurs, we will have a cease and desist notice, then file complaints with courts and IP bodies and ensure that your resolution, that is our damages or civil litigation is done and you get the result in your favor. Then importance of IPR for entrepreneurs. First thing is protecting your innovative ideas being copied. Second thing is you build a brand interest. Just we have seen the example of Pepsi, which they have built their brand of that trademark red, white, and blue. They are building their brand over for 30, 40 years. So we have the recollecting value on all those things. So the brand reputation and trust comes up with just the trademark. Tomorrow, if I start a company and I sell a soda or a Coke outside, and the same time Pepsi is coming up with their product with just the brand logo, people would prefer the brand Pepsi more than an individual. So that's how powerful the IP is. So enables monetization through licensing and franchising, which we already discussed. A coffee shop example of copy day, which I have given. So that monetizes and franchising and licensing also will give you a lot of money over that and attract investors and funding. So practical challenges for the startups, high cost of IP registration, which can be solved by government subsidization. Say in this example, we saw that 80% of being subsidized by the government. Then lack of awareness is what uh, big challenges. So a lot of innovations and these trademarks are being exploited due to this lack of awareness. So lack of awareness should be cut out. Infringement risk and litigation issues. So this has to be taken care. Then international protection complexities, wherein we have a situation to go to international forum and solve our IP disputes. So case studies, coming to case studies, I'll run through this case studies example. So this is with regarding to Milk Mantra, a company. So this case is Milk Mantra and Moo Shake, a patent-backed innovation. So this is a Odisha-based startup. It ran under Mooshake. That is the brand. So Milk Mantra is the company and Mooshake is their brand. So they secured US patent for health-oriented milkshake formulations. So this patent is across all. This patent is now applicable all over the world. So they patent that milkshake and it could be used across the world now. So these patents provide legal safeguarding, enhance credibility, aiding them standing out in the dairy sector. So we could find Amul, Avin, Nandini. So all these things are traditional players wherein they don't innovate. There is no idea of innovation initially, or there is less idea of innovation, wherein this company has put in your idea into innovation back to execution. So this thing is a big, great example for entrepreneurship that is backed by IP also. They have obtained a US patent, which is not an easy job. So they have done through all the procedures and got this patent for specifically this. So this would encourage a lot of people. This would fetch them a lot of eyeballs. This will fetch them a lot of investors. This will also give them a lot of customers trustworthiness. Say if they run that Milk Mantra US patented product, that would also bring them a lot of customers. And second case study is regarding Bikanadi. Bikanadi is a place. Bikanadi, Bujia got a geographical indication. What is geographical indication? Belongs to a particular geographical place. So it is a traditional snack called Bikanari Bujia, received geographical indication. Officially, it is got that name from Bikaner. Bikaner is a place. They got that Bujia. The Bujia is a particular product they do. So they do was Bikanari is the name they got the geographical indication for. Why it matters? Geographical status provides the local heritage. It has been sourced from the Bikaner area is what the geographical indications will convey to the customer. It gives the brand identity. So there can be, so I have represented as Bikaji as a brand. There can be another brand which also can do this Bikaneri, but the product has to be coming from Bikaner. So that is the catch here. So use of geographical indication, that is very important. It boosts cottage industries in the Bikaner area that can copy, so that would stop others from copycatting that name, and their quality will be maintained from that particular place. That place is Bikaner. So next case study is Zostel versus Oyo. So here, Zostel and Oyo had a secret issue. So this is a high profile dispute. You know, Zostel is an international company and Oyo is an Indian startup. Uh, so there was a merger talk between Zostel and Oyo, and during the merger talk, there was the uh, business model of Zostel was shared with Oyo, and the ruling favored Zostel at the end, and Zostel were given a stake in Oyo after this dispute. So always use the NDAs airtight. So everything has to be covered in your NDAs. Everything has to be reduced to writing is what the legal term they say. Everything has to be reduced in writing. Airtight is like there should not be any gap or loopholes to the other person to escape. Say in this case, just because their NDA is very great and it is very strict and it gives them airtight protection, Zostel could win a stake in the OYO. So otherwise it would have been difficult. Then story of Ola cabs. So there is a we know Ola is famous across in India now with regard to cabs. So there is something called Ola Tours which came up. Ola Tours and Ola per se can be different, but then the same sounding of Ola would think that people may think that Ola is another company is Ola Travels and Tours, but that is not the case. So in this case, A&A Technology is the parent company of Ola. They won the legal battle. That sounding deceptively similar, so that could also fetch their customers from Ola to Ola Travel Tours. It can lead to decepting the customers is what decided in the case. So the decision reaffirmed that securing trademarks to avoid brand dilution. The dilution part which we have seen that in the trademark is the example of this. This is regarding a case of Bharat Pay and Phone Pay. So mostly you could have seen Phone Pays, Paytms and Bharat Pays in the UPI world. So trademark dispute over generic term, generic term. So the generic term here is pay. That is Bharat Pay, phone pay. So the ending is with pay. So here pay is represented as PE. The phone pay came up with first, then Bharat Pay followed it. So mere using of the word pay, pay meaning on Hindi is say pay means it's a English word. In Hindi they have used as pay. So that is not that's a generic term. It can't be protected, is what they claim. Court held. So the distincting trademark. So here, Paytm is different. So if they have used this Bharat TM, then the category is entirely different. But here, Pay is a common name. That is Phone Pay, GPay. Everything is common. Pay is a common English word. It's not a specific word which has been trademarked. So that's what held in this case. Uh, with regard to these logos, you could identify Flipkart, Paytm, and Ola. So here there have been patent disputes. Flipkart protects its logistics algorithm and UI innovations to deter competition. Say all these companies, what they used to do, they'll have a dark store model or a bigger uh, storage model. They now employs their real-time app monitoring system. Say if I type for a shoe, a particular brand of shoe in Flipkart, Flipkart won't be waiting for my order to take place and then ship the product to the particular warehouse nearby me. Say if I live in Chennai, there is a well-established branch in Chennai, warehouse in Chennai, which has a capability to serve say over 1,000 pin codes around Chennai. So seeing the demand of the product in the particular place itself, Flipkart will have this logistical algorithms which will put such product to be stocked up in the warehouses. That's how they deliver the products quickly, say within 1 day delivery or even uh, when deliveries under minutes. They ensure that these things are done using this algorithm. These algorithms are patent protected. Then Paytm safeguards its payment gateway and wallet technology also through payments. So everybody might have used their Paytm, so their wallet technology and payment gateway is also protected. Then Ola patented its ride allocation. Say if you booking your ride and it allocates to a particular driver, and there is also a pricing mechanism. Say if you are booking at a 5:55, that is your booking time. Then your price is say 150. If it is 6:02, the time is 6:02, your pricing becomes 180. So it is decided by the algorithm. There can be only a few minutes difference between the two times, but the algorithm says that after 6 it's peak hours, so the price may be hiked. So all these things are their ride allocating and pricing algorithms. So it is also being patented. This regard to Zomato and Flipkart and Grabon. So Zomato has trademarked their logo and taglines and red color branding to ensure that customer recognition. So it is clearly divided in India that if it's red, it means Zomato. If it's orange, it means Swiggy. So these things are created. So these things are emphasized and the brand protection was ensured in Flipkart versus Mark Enterprises and Grabon versus Grabon Rent, similar to what we have discussed in Ola and Ola Tours and Travels. So one more thing is Byju's has cooperated is educational content and pedagogical materials to safeguard against replication. This is protected under copyright. So you know what Byju's is? Byju's is a learning app. So earlier it used to be very successful. A lot of learning contents were put it online, and all those contents are being copyrighted in order to avoid any duplication by others. So with regard to case study, another case study regarding designs. This is Rahul Mishra. You can see him in the right, far right. He's a fashion designer. He are commenced against the a tigress motif. What is the tigress? We'll see the designs. So this is protected under copyright law and design law under 2000, Design Law Act 2000. So like logos, product aesthetics for exclusive use. So you can see the tigress here. So this tigress design is created by him. So Delhi High Court ruled in favor of Rahul Mishra in the theft case, counterfeit clone one by certain celebrities. So it is also reported in Economic Times also. So that's it from my side. Any questions you can ask me, and you can find my LinkedIn profile with this QR code also. You can follow me. Thank you, and I would request you to send your feedback regarding the session to me. Thank you. Thanks a lot.
Thank you, thank you, sir, for such an insightful session. I'm sure each one of us would take back important learnings from today's lecture. The worldview of IPR that you gave us was truly enriching, and so were your inputs on the government initiatives for the startups. and all the aspiring entrepreneurs, I'm sure, will would have loved the session. As we approach the end of this program, I would like to express my heartfelt gratitude to our Dean Academic, Professor Dr. Neelam Saxena, for her encouragement and support. I would also like to thank our faculty conveners, Professor Dr. Govind Prasad Goel, Assistant Professor and IIC Coordinator Ms. Shobha Tripathi, and Assistant Professor Mr. Santosh Sati for their guidance. I would also like to thank my fellow student conveners, Startup Coordinator Mr. Sanskar Singh with his team, Mr. Yuvraj Sharma, Mr. Krish Tyagi, and Ms. Kritika Gupta, who helped conceive, coordinate, and execute this program. And finally, I would like to thank our esteemed guest, Mr. Balaji Damo, for his time and valuable inputs. And of course, thank you all for your presence. It made all the difference. Thank you and have a great evening ahead. So with that,
Yes, sir.
just a reminder, Yuvraj, you were giving the QR code.
Yes, so everybody, all the students
Thank you,
who
sir.
joined this session, I'll be sharing a QR. You can scan that, fill the form, and you'll get
Yes,
your
sir.
e-certificate.
Perfect.
Okay, so
So,
wait here
so
for 2 minutes, fill that form, and
yeah,
then you can leave.
yeah. Yuvraj, take your time.
Yes,
Just
sir.
float the QR code. Somebody wants to ask a question. Yes, Mr. Goswami. Mr. Goswami, you are on mute. Uh, Yuvraj, could you please unmute Mr. Shubhadeep Goswami? He wants to ask a question.
I've done that, so can you please try unmuting and unmuting now?
Can you
Yes,
hear me?
yes, sir, you're
Yeah, we
audible.
can. Yeah.
Uh, uh, Advocate Damo, it was a very good session on your part. And I am doing LLB in IMS just to enter
Yes.
the patent IP field. I have a very strong background in chemistry and chemical technology. I have a dual post graduation in MSc chemistry and MTech biochemical engineering. And I have over 20 years of experience in the pharmaceutical industry as a consultant in the field of competitive intelligence, business intelligence, and research. And such research is always backed by science. Pharmaceutical industry is
Yes, sir.
basically a chemical industry
From
backed
what
by
you have told
science.
me, the information, I could draw inference
During
that
my days
you are asking
in
what is your
my
scope
own
of your
business and
LLB.
corporate, I used to
Post your
hear a
LLB, what
lot
will be
about
the
intellectual
scope of your
property,
LLB,
and
right?
people used
So the
to
thing
run
is,
to
you
some
have an
lawyer to
edge of
file
a
some
person with a 20 years
scientific
background from
patent,
a chemical
which
engineering
I
background.
understood the
So
process,
you
but
will
I did
be
not know what
knowing a lot
exactly
of
they were doing
things
in the
like
patent
a
field.
chemical compound,
And
what
they
is the
used to struggle
combination,
to
and you can be a
explain
very
the
great
lawyer
IP
what the
lawyer
process
with
was,
related
because the
to
lawyer
patent,
is an
and
LLB,
you
but he
can
does not
choose your
understand the
specific
science.
niche to be pharmaceuticals patents. So
But
with yeah,
if I
in my
am able to
presentation, I
do
have discussed
LLB,
something regarding a product patents.
I will
So
understand the
post the
law,
2005
and my
amendment, we
core
have
competence remains science
uh,
and technology,
lot of important
chemistry.
things happening around that space.
What
So in the
exactly
pharmaceutical space,
a
you have a
lawyer
great
in the
opportunity
patent
wherein
field does?
you have the
I am very
expertise of a
curious
chemical
because this
engineer
is
and
what I
then
want to
the
do.
procedural
That's
capability
why
of
I
a
am
lawyer.
doing LLB.
After you have been studying this particular IP field, that too, if you specialize in patent, you will have a great scope because there are a lot of corporations which demand the important role of a person who is capable of handling patents. That too,
Yes,
with regard to specific companies like Dr. Reddy's, Cipla, and other important medical companies, they will be having their in-house counsels, and also they require a specific person to convince the court with regard to the certain issues which comes related to this patents. So you can choose that to be your niche, and then you can work on it, sir.
yes.
Uh, yes, yes. So in India, you can't compare the system which is there in US with India. So India, it will same advocate will be handling civil, criminal, everything, litigation, everything put together. But then in US, it is strictly based on your niche. You will be treated as your say, as you said, the patent attorney, the entire work of him is end to end the patent work. Say if I'm a chemical engineer, I don't know nothing about IP. I go to this patent attorney, I will tell them what is my product and how would I have arrived this. he will be having a specialized knowledge, just like you. In your case, you have a 20 years knowledge on that particular chemical analysis. So you will be, if you are the patent attorney, you will be in a
Uh,
position to
uh,
understand that
my clientage
chemical
was mostly
complexities
in the
better.
US,
So you will
and
be in a
there
better position to
there is,
convince that
they used to call
patent issuing
patent attorneys,
authority, to convince them that
attorneys.
there is innovation,
And
there
we
is
have a
novelty
concept
here.
of patent
So
attorney in
you, the
India.
pay which the IP attorney gets there in the US will be very high. So comparing to when India, if you specialize, you could reach that level. So it's these areas are growing now, and there is a lot of scope for that specific niches. Yes, yes. So, so there is so it depends upon your skill and your understanding and how you can put it before the court. It doesn't matter which jurisdiction you practice, because IP is across jurisdiction. You can practice everywhere. It's your depend upon your skill. You can practice anywhere.
I have never
Yes,
worked
sir.
for Indian companies, to be very fair, and
Sure,
I
sir.
have
Sure,
no
sir.
idea whether Dr. Reddy
Yes, sir.
respects or wants such
Sure, sure.
people who
Yes,
understands the chemistry of their product and also understands the law. And if there is a
yes.
dispute, he goes to the court as a subject matter expert, because in the court the law will be explained less, the chemical process will be explained more, and why it is
Yes, sir.
innovative and why it is different. The law
So
aspects will be very less.
I have dropped in
That's
my
what I
LinkedIn
understand. If
profile
there
in
is a
the
court case,
chat box, sir.
if
You
there
can
is a
connect
case.
with me and we can discuss, sir. Thank you. Thank you.
In case you have some cases like this, we can get in touch to it will help me understand the
Yes, sir.
process, the law aspect. IMS will definitely teach me the law aspect. They are teaching me. I have just joined in, but there is a practical niche aspect of it. Suppose you get a case from, say, a Pfizer about to file a patent on a particular thing. Uh, the, uh, it will be a great practice and understanding for me to join you from here in Delhi, in Ghaziabad, and give some inputs about what I can contribute. Thank you, sir. Thank you very much.
Anybody else has any question for Mr. Balaji Damo?
Thank you.
They can raise their hand if they have. Anyone else, or do we close the session?
Where is the chat box? I am not very good in tech.
So that should be on your right hand side corner, bottom corner. So I hope everybody has copied and clicked the photo of the QR code.
No, 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 no. I have not.
So if you could just do that, and then we'll close the meeting.
It is to be done with the mobile camera.
Yeah, just go on to Google, and on the right hand side, you'll see a camera button. Just
Just the
click
Google. Okay, okay.
on that.
And then what to do? Search.
Yeah, search, and then you will have a forms link coming up, and you have to fill that form.
Okay. Thank you, ma'am. Thank you very
Thank
much.
you so much. So thank you all, and it was wonderful having you all with us. And have a great day ahead. Bye bye.
Thank you.
Thank you.
Thank you, sir.
Ta-da.
Thank you.
Thank you, sir.